ourselves for a word of prayer. Heavenly Father, we would like to thank you for this moment that you've graced this occasion to start here in Uganda. We thank you for your very presence and making it possible for delegates to come from the different parts of Africa to join us in this beautiful country, Uganda. We would like to thank you for the fact that the occasion is happening here, and we pray that your grace partakes at this conference for the days to come. We pray, O Lord Father, for the leadership of this country to guide us through, and we pray for the leadership at URSB to also guide us through, as well as the leadership from ARIPO. We thank you, Lord Father, that the occasion is here and the day has come. Thank you, Heavenly Father. We pray all this through the name of Jesus Christ our Lord. Amen.
Thank you, Paul, and you may be seated. Distinguished ladies and gentlemen, allow me to make a few remarks before I invite the speakers for the day to make presentation. We have online presence. We have delegates attending online from ARIPO partner states and also cooperating partners who are joining us via Zoom and other media platforms, and they are streaming live from their various jurisdictions. The guest of honor, the Honorable Attorney General, Mr. Chiriowa Chiwanuka, the Chairperson of the Admin Council of ARIPO, Honorable Adeline Cooper, the Director General of ARIPO, Mr. Bemanya Twebaze, the Registrar General of the Uganda Registration Services Bureau, Ms. Mase Chomgashoki-Noguisho, distinguished representatives from ARIPO cooperating partners, our key sponsors, AFRIP, members of the media fraternity, ladies and gentlemen, a very good morning to you once again. We welcome you to this very important occasion, the grand opening that will climax into the adoption of a protocol on voter registration and notification of copyright. It's a great honor, privilege to have in our midst the Attorney General, our dear Attorney General, and so we welcome you. Thank you for honoring this invitation and coming here to be with us. In the same spirit, we would like to thank you very much for finding time to leave your busy schedule, especially in these trying times of COVID, and joining us physically. For those of you who have been able to make it here physically, but also to recognize and appreciate those of us who are online and following the proceedings of this morning. Without much ado, and in the interest of time, allow me to invite the first speaker this morning. The first speaker is a distinguished lady, an expert in intellectual property. She is the former head of IP at the Uganda Registration Services Bureau office, and now Registrar General. Ladies and gentlemen, join me to welcome Ms. Mase Chomgashoki-Noguisho to address us this morning. Thank you.
Our guest of honor today, our dear Attorney General of the Republic of Uganda, Honorable Chiriowa Chiwanuka, commonly known as KK, the Chairperson of the Admin Council of the African Regional Intellectual Property Organization, Honorable Adeline Cooper, the Director General of the African Regional Intellectual Property Organization, Honorable Bemanya Twebaze, distinguished representatives of the African Registration ARIPO cooperative partners that are represented here, the members of the media fraternity, our online delegates, ladies and gentlemen, colleagues from URSB, and all the ministries, departments, and agencies of the Republic of Uganda, you are very welcome. It is with great honor that we welcome you to Uganda, a country gifted by nature, the Pearl of Africa. I know as the intellectual property family, this might be the first conference in like 2 years since the COVID-19 pandemic struck this globe. And we want to appreciate God for the gift of life. We do not take it for granted, but also commiserate with the families that have lost their loved ones during this COVID-19 pandemic. And as we continue to observe the standard operating procedures as advised by the World Health Organization and by the leadership of our countries and nations, I would like to welcome you once again to this diplomatic conference, the experts group meeting, and other meetings that we will have along this 8-day engagement. Uganda Registration Services Bureau is the National Intellectual Property Office of Uganda. Uganda has a national intellectual property policy that was launched by His Excellency the President of the Republic of Uganda in September 2019. And this policy supports the legal and regulatory framework that we have as a country. And we must say that Uganda is one of the best countries that has the most updated laws in as far as intellectual property is concerned. I know many of you have read about Uganda as a country and its resources, but maybe you have not explored the intellectual property resources that we have. And that is why we are gathered here as experts to discuss interventions that can be made in as far as the African continent or shaping the innovation landscape of Africa in terms of intellectual property generation, intellectual property protection, intellectual property utilization, intellectual property commercialization, and intellectual property enforcement in our nations. We appreciate the value proposition that copyright adds onto our different sectors of the economy, and copyright being one of the categories of intellectual property, and is the reason why we are meeting to protect and enhance the protection for the literary, artistic, and scientific works in our nations. As members of the African Regional Intellectual Property Organization, we appreciate the progress that our countries have made. We want to take this opportunity to appreciate the role that ARIPO plays in our country. We want to appreciate the role that each individual country plays in shaping the landscape of intellectual property in Africa, and specifically copyright. We want to appreciate the role of our partners, AfriIP, represented by Gregory and Dennis here. We appreciate your support and thank you for making it all the way. With these few remarks, and with special appreciation to ARIPO once again, allow me, colleagues, members present, delegates here attending physically and virtually, to take the honor of inviting the Director General of the African Regional Intellectual Property Organization, Mr. Bemanya Twebaze, to make his remarks. I thank you very much, and I wish us a good deliberations as we continue to observe the SOPs that have been put in place to observe safety. I thank you very much, and for God and my country.
our guest of honor, the Attorney General of the Republic of Uganda, Honorable Chiwanuka Chiryowa, the Chairperson of the Administrative Council, ARIPO, Honorable P. Adeline Cooper, the Registrar General of the Uganda Registration Services Bureau, Mrs. Mase Keinobwisho, distinguished representatives from our cooperating partners, Den Shears, Gregory Shenda from AFRIPI, Honorable Attorney General. AFRIPI is a project that is being supported by European Union, and they have played a big role in our being here today. Distinguished delegates here present, our online delegates. I know COVID has challenged us, but also created opportunities. Honorable Attorney General, we have delegates attending from all over the world. This function is being live streamed. Members of the media, ladies and gentlemen, I'm very honored to welcome all of you to this meeting of the experts of ARIPO member states gathered here today to negotiate a draft protocol on voluntary registration of copyright and related rights. The expert session is a prelude to other important meetings that will be taking place here in this beautiful city of Kampala. And they will constitute the 11th extraordinary session of the ARIPO Administrative Council and the Council of Ministers, who will meet to adopt and assign the protocol at the diplomatic conference. At the outset, I would like to express my deep gratitude to you, our chief guests, for taking time, your busy schedule, to officiate the opening of this meeting. Let me also take this opportunity to congratulate you, our chief guest, upon your appointment to the distinguished office of Attorney General and the responsibility that it holds in the Republic of Uganda. Indeed, a well-deserved appointment of which the people of Uganda will benefit. I paused, I don't know what was happening. If we wish to congratulate the Attorney General, we congratulate him. Thank you, thank you. That's the befitting congratulatory sense that that when he stands up to speak, you will even regret why you didn't stand up for an ovation, but it will be another time. There will always be opportunities. So, Honorable Attorney General, I'd really want to congratulate you upon your achievement and the impact you create to make a difference in people's lives. The teaching you do, not only for Uganda, but for the region, for Africa, and for the world. And that's why I'm extremely excited that you found time to be with us this morning. Our chief guest, the African Region Intellectual Property Organization, is an intergovernmental organization that was established in 1976 to promote harmonization and development of intellectual property laws and to establish common services for the coordination, harmonization, and development of intellectual property activities affecting the member states, but also that create value for Africa. ARIPO currently administers 4 protocols covering patents and industrial designs, trademarks, traditional knowledge, and plant varieties. Accordingly, through ARIPO's governing bodies, namely the Administrative Council, which comprises of the heads of the IP offices in the member states, Council of Ministers, which is the supreme body for ARIPO member states, resolved to address the gap in the area of copyright and specifically the gap of copyright in the ARIPO region. Dear Chief Guest, copyright protects expressions of literary and artistic works. It is the most abundant form of intellectual property among the 20 member states, and yet it is not fully exploited. This meeting is the beginning of the end in terms of closing the gap with respect to harmonization of copyright protection mechanism in the region. I know, Honorable Attorney General, this is an area that is extremely important to you. I know it's extremely important to all the member states. And I know standing here, we are intentional to change the trajectory, to change the way we've been looking at this resource, because it will change people's lives in very meaningful ways. Gathered here today, dear Chief Guest, are experts from 20 member states whose objective is to negotiate terms of this protocol. The journey to this point began with consultations of member states who have engaged the Secretariat up to this point where the text of the negotiation is mature enough to be subject to a diplomatic conference for adoption. I will therefore like to take this opportunity to thank all our member states for their invaluable contribution in reaching this far, and to invite you to experts to critically scrutinize the draft protocol to ensure the final text that will be adopted and signed in the diplomatic conference is a true reflection of the needs and aspirations of our member states in the field of copyright and related rights. Dear Chief Guest, we are beginning this conference in the midst of the pandemic. We commiserate with those who have lost their loved ones, but also celebrate the healthcare professionals in their various capacities for the courageous efforts in the face of this pandemic. I further would like, through you, our Chief Guest, to thank the government of the Republic of Uganda that has demonstrated the attributes of leadership in crisis. Leadership in crisis is extremely important because it gets people out of the woods, shows them the way, shows them that there is hope ahead. And your government has demonstrated this. And indeed, these delegates, almost all of them, were calling me up to ask, are you sure Uganda is still hosting this conference? And I would assure them that in spite of the pandemic, Uganda has put in place systems, procedures that will ensure a successful diplomatic conference, but also will ensure that we are all safe. I wish, therefore, to thank you very much for ensuring that we have this meeting taking place in Kampala. So let me thank, through you, our Chief Guest, the government of Uganda for really stretching and ensuring that we are here today. My deepest appreciation also goes to the Registrar General of Uganda Registration Services Bureau, Mrs. Maseke Inobwisho, and her able team for the great work they did in organizing this event. I particularly wish to commend the great collaboration of her office and the ARIPO Secretariat in the preparatory phase of the diplomatic conference. Sometimes when you stand here and give these speeches, people might feel that you had to say that because it's a diplomatic conference. The truth of the matter is, when Honorable, the chair of the Admin Council, and myself, and a team from the Secretariat, and a team from member states arrived here in Kampala, it was past midnight, 2 a.m. The Registrar General was personally there to receive us and ensure that we are safely at the hotel. For that, Madam Registrar General and your team, I would like to thank you very, very much for demonstrating leadership. It would have been easier for you to send your team, but you led the way, continue to lead the way, and I know we shall continue enjoying our stay here in Kampala. That diplomatic conference benefited a lot from support of our cooperating partners. In particular, I wish to thank the European Union for having availed sponsorship to the Africa Intellectual Property Rights and Innovation Project, AFRIPI. I would like to greatly thank you, the representatives here present, for ensuring that not only did you support, but you've been here in person to even give more support. The reason you had those claps around is to thank you. The other reason is that we expect more cooperation from you. We expect to be real partners, and the project of AFRIPI should be focused on delivering impact. Sometimes we have projects and they come, you tick off, but how can we focus this project to deliver impact and transform people's lives? So we shall continue appreciating you for what you've done and for what you are yet to do in this journey of transforming people's lives. So the sponsorship, Honorable Attorney General, covered various items that include air tickets for all experts and staff members of the Secretariat, as well as the hiring of the venue of the meeting. Thank you very much for the support to ARIPO that will go a long way in strengthening our legal framework. Guest of honor, ladies and gentlemen, as I conclude these remarks, I would like to thank once again the government and the people of Uganda for the support to ARIPO in general and the diplomatic conference in particular. Those of us who were flying in can testify, like I've already said, to the hospitality, safety procedures, and security for which we are most grateful. Thank you all for listening to me, and I wish you fruitful deliberations. Thank you. I now have the honor and privilege to invite the chairperson of the Administrative Council, Honorable Adeline Cooper. Honorable Adeline Cooper is the reason we are here. Before you take the podium, Madam, I would like to make it clear that as chairperson of the Administrative Council, you've given the Secretariat support, you've given it direction, you've given it passion, and for that, we are extremely grateful. And would like to thank you for finding time to be here. May I now invite you to give your remarks, Honorable.
The guest of honor, Honorable Kayowa Kiwanuka, Attorney General of Uganda, the Director General of ARIPO, Mr. Bimania Twebezi, the Registrar General of Uganda Registration Services Bureau, Mrs. Mercy Kanobisho, members of the expert committees, representatives of cooperating partners, our virtual delegates, members of the media, ladies and gentlemen. I wish to first of all express on behalf of the Administrative Council of ARIPO my sincere appreciation to the government of the Republic of Uganda for having offered to host the diplomatic conference for the adoption of the draft protocol on voluntary registration of copyright and related rights. It is so good to be in Kampala. I'm enjoying the hospitality of this beautiful country. Guest of honor, thank you for having accepted to officially open this meeting of experts who will be considering a draft protocol that will be further reviewed by the 11th extraordinary session of the Administrative Council before finally submitted to the diplomatic conference for adoption and signing. I also want to thank experts who managed to travel to Kampala despite the current circumstances of the COVID-19 pandemic. In equal measure, I thank other experts who are attending this meeting virtually. Guests of honor, ladies and gentlemen, my appreciation also goes to the Director General of ARIPO, Mr. Bimania Twebazi, and his team at the Secretariat who worked tirelessly to ensure this session, as well as the two other meetings that will follow, are seemingly held despite the difficult conditions prompted by the COVID-19 pandemic. I wish to thank the Director General especially for having kept me informed on all steps of the preparation of the diplomatic conference. I was also duly informed that the team at the ARIPO Secretariat worked hand in hand with the Uganda Registration Services Bureau. I wish to commend my colleague, the Registrar General of Uganda Registration Services Bureau, Mrs. Mercy Kanobisho, for that. Thank you very much. Guests of honor, ladies and gentlemen, we are gathered in Kampala to discuss a protocol that is expected to set a framework for ARIPO member states and Africa as a whole to protect their creativity industry by ensuring that the creators benefits from their creative works. I am delighted that the diplomatic conference is preceded by this meeting, which is bringing together copyright experts from ARIPO member states. I have also noted from the program that there will be a presentation on the experience of Hungary on the voluntary registration of copyright. Let's ensure this is an opportunity to clarify any gray area, as this protocol is the first one of its kind in Africa. Guests of honor, ladies and gentlemen, before I conclude my remarks, I would be remiss if I did not express ARIPO's gratitude to our cooperating partners for their unwavering support to ARIPO, especially the European Union, who sponsored to a great measure the diplomatic conference through the AFRIP project that is being implemented by EU IPO. Finally, allow me to conclude once again by thanking members of the experts committee who made it to Kampala, as well as those attending virtually. We have a lot of expectations from this meeting, as your work will ease the text of the Administrative Council that will consider your report in the session next week before submitting the final text to the draft protocol to the diplomatic conference for adoption and signing. Mr. Guest of honor, ladies and gentlemen, thank you very much.
Thank you very much, Honorable Adeline Cooper. May I request, though, with the utmost of humility, that you invite the guest of honor to make his remarks. Thank you so much.
Ladies and gentlemen, on behalf of the Administrative Council of the ARIPO member state, we would like to welcome our guest of honor, the Attorney General of Uganda, to the podium to make his remark. Thank you very much.
You see, before I start the speech, I think that is the worst part about being the guest of honor is you get to speak last. So everyone has said everything that is nice, and then you become the one who is plagiarizing. And since we have the people of ARIPO here, please, I came with my speech written. So, yeah, the Administrative Council Chair, Ms. Adeline Cooper, the Director General ARIPO, my friend Bemanya, the Registrar General, URSB, Mercy, the distinguished delegates for ARIPO here from the member states, you're most welcome. And obviously our virtual guests who are not here with us. Our partners are FRIPI, thank you. The staff of URSB, Uganda Registration Services Bureau, ladies and gentlemen, good morning. I don't know how many of you here play golf. I only know Vincent here who plays golf. But for those of us who play golf, we have something we call a head up. And I must register my defense early enough. This is my first outing out. I've just been in office for about a month, so this is my first official outing. So if I have a head up, please forgive me. Ladies and gentlemen, welcome to the Diplomatic Conference on the adoption of the draft protocol on the voluntary registration and notification of copyright and related rights. I want to thank the Registrar General of URSB for her remarks, the Director General, and of course the Administrative Chair for your remarks, but more importantly for the commendable job she has been doing at URSB, and specifically for organizing this conference. I think it's most fitting for the passion and purpose by which URSB works that this conference is held in Uganda at this time. Thank you very much. Uganda has come a long way, not only in terms of governance, but in policy as well. As mentioned by the Registrar General, we recently launched our protocol, or our policy on intellectual property. And this is really something that is very big on our agenda as government today. For those of you who follow, you realize that we now have a Ministry of Science, Technology, and Innovation. And that ministry has been taken into the President's office. It's very, very important that this particular conference is being held in Uganda at this time. Uganda has implemented, in addition to this, Uganda is implementing its NDP 3, the National Development Plan 3, whose goal is to increase household income and to improve the quality of life of Ugandans. Therefore, the protection of intellectual property is therefore very, very vital in realizing this goal. You can imagine where we are seated here, it's just full of intellectual property. For those people who are not, for those of us who were not here a long time ago, many of these things were not here, starting with the clothes, the chairs, the computers, the microphones, all that came from thinking. So we take the process that you're going through today here as just part of that big journey that we have to take as a country and as a people. As most of us know, copyright is a right granted to the authors and owners of literary, musical, and artistic works, among others such as software, and there's so many other things. I cannot really preach to you about this. You're the experts who are here to discuss this. The protection for copyright is granted as of right. And it's a lifetime, but you see, it's not, what we are discussing here is to encourage people to voluntarily register. I mean, I have my right, I sing my song, the right is there, but now what we are discussing here is to get that protection and formalize it. The nature of copyright protection is not dependent on registration. That's very important, and I think that's what makes this conference, this retreat, this thought process extremely important. But rather, it is automatic upon publishing of the work. As such, registration of copyright works is a rare practice amongst authors and owners of the same. In Uganda here, for example, I can tell you, and I hope as I finish, I'll guide you to how we can achieve this. You can go out to a party at least before COVID, and have no song other than Ugandan songs being played throughout an evening, running. Obviously, I'm talking about this before the time I was Attorney General. I don't do this anymore. Well, for time running for very long hours. And that time, you would find only Ugandan songs, but when you went into the register to find out how many we have on the register, you probably find none. And that means it's either ignorance and this is what we are trying to deal with here. So voluntary registration embodies various benefits to both the country and to the authors of such works. And it's for this reason that we are gathered here for this conference. For instance, voluntary registration of copyright works to help engaging the country's innovation and the creativity activities. That's the only way we can know. Are we thinking? Are we working? Are we trying to get ourselves out of a space? The only way we can do that is by having these registered. Most importantly, for the author, voluntary registration serves as the authentic evidence of the copyright, which can also be used in courts of law. But this is property you can actually pass on to someone. It's real. When you have it registered, it's not the same thing as passing on a CD and say, this is my song. You know, it's different, and this is important. I was chatting with Mercy, Adeline, and Bemanya earlier and said it is really unfortunate that has happened in a COVID time that we had not had an opportunity to have a crowd of the people who are out there who could actually sit in and really watch and understand and listen to what the experts have to say during this time so that they could learn, because this is an opportunity that Uganda would really have loved to have its people hear from the experts, hear the experiences. I was just hearing about the experience in Hungary. Would have loved for these people to hear about it, but I've been assured that this is being live streamed, and I know how URSB works. I am sure everyone is out there trying to follow what is going on, and we hope to reap the greatest benefits out of this event. These and many other benefits prove that voluntary registration, even though not mandatory, is necessary in enforcing copyright protection. It is something we desire for our citizens. It is something to enable them have confidence and maximize the full benefits that attract to their innovation and their thoughtfulness and their intellectual property. To this end, I would like to commend ARIPO for the initiative in adopting the protocol for all the member states, which shall ensure that the copyright registration and protection will be done and recognized among the member states of ARIPO. It is encouraging to know that as a country, voluntary registration has been encouraged by URSB because it has been done. They've been trying, and we know that they've been trying, which indicates that we are on the right path. So as the delegates come to join us, we know that you have been trying in your places, but we want to assure you we are also trying. And as we get these protocols together, we shall do everything that we can do as a country, as a government, to make sure that this works. As a country, not only are we proud of this historic diplomatic conference, but we hope that the deliberations we have hereafter will result into an instrument that will significantly improve the protection and enforcement of copyright in our respective jurisdictions. Before I take leave, I must tell all of you delegates, those of you who are here in person and those who are out there virtually, that you have not seen Uganda until you've seen it all. So make sure you do not leave this country before going out to visit, and I am sure you are in very safe hands with Mercy. We are gifted by nature. We have the most beautiful climate. We have the most beautiful environment. Every animal you can think about is here. All you have to do is just go a few paces out of town. Please make sure you see the wonders of Uganda before you leave. But remember, as you enjoy Uganda, COVID is real. We need to protect ourselves. We need to thank God that we are here. Keep your mask on, wash your hands, and keep a safe distance. For us, we say here, Tonsemberera. So every time you find a Ugandan coming near you, please say Tonsemberera. They will understand exactly what we are saying. I wish you the best in this deliberation, and let's pray that this protocol will change our lives forever, and we can take our place in history that we were there when we started changing the lives of the people of this country and the member states and the world at large. Thank you all very much for listening to me, for God and my country.
Ladies and gentlemen, let me invite us again to give a round to the guest of honor for their very wonderful words. Thank you so very much, our dear guest of honor, and I can assure you that that was an albatross. You did exceedingly well, assuring our people about the health and safety that we have in place. We can only add and say that we will try our best to observe the SOPs, because indeed COVID is real, and we don't want to end up in a bit of a mess. So kindly keep the masks on. I know that there's a bit of temperature rising, but we can't do AC because we know that it's a source spreader. So you bear with us. We'll try our best to have our natural aeration working. Uganda is indeed gifted by nature. I would like to invite the Registrar General to make a slight comment, and then we can carry on with the program. Madam Master, please.
Thank you very much, MC. Our Honorable Guest of Honor, Honorable KK, the Chair of the Admin Council, Honorable Cooper, and DG, ARIPO, Honorable Bemanya. I know many people continue to enjoy the environment and the services here in Uganda as we prepare for a 7-day engagement here in Kampala in a very beautiful environment of Munyonyo Speak Resort. This wouldn't have been possible without the people that have put their labor, the skill and knowledge together in form of organization committee. And Honorable Guest of Honor, I'd like to present to you the team that we're going to be with for the next 7 days that have planned this event, headed by Mrs. Carol Egesa. Please walk in with your team. If you know that you're on the organizing committee, Mr. DG, you'll allow me to also invite the ARIPO team, because we've been a family, we've been working together, headed by Madame Hillary. Please, the ARIPO organizing committee. We had a joint committee. Please walk up front. I would like the chief guest to recognize you, to appreciate your efforts. It's been months of planning. So far, so good. You delivered what we asked for. And in the next 7 days, we know that it's going to be even better as we host our President of the Republic of Uganda, who will come to the diplomatic conference. I thank you very much on behalf of Uganda, and do I have the powers of attorney, DG, to say thank you to your team? Thank you very much. Thank you very much. Thank you very much, the ARIPO team. You have done well. The Ugandan team, the organizing committee, thank you very much. God bless you.
Thank you so much, Registrar General, and indeed thank you very much, the organizing team, for a job well done. We believe that through the 7 days, we'll have a seamless conference, and we thank you for your efforts. We are not running well with time, but we'll have to try our best and work within what we have. At this juncture, I want to make a few announcements that if you need a place of convenience, you'll go through the door, take to your right, you'll see another entrance, and then when you enter through, you'll see a corridor that goes right behind the building. You'll see the various places of convenience. We also have some Wi-Fi for those of you who might want to use it. I think there's something on your table. But most importantly, there's a conference book. This conference book has quite some information that you might find relevant in your stay in Uganda, but also during our conference meetings. That said, I would like to invite our next speaker. Our next speaker is from the Hungarian Voluntary Registration System, Mr. Peter Lambodi, the head of copyright at HIPO.
Good morning, ladies and gentlemen. Dear guest of honor, dear chairperson of the Administrative Council of ARIPO, dear Director General of ARIPO, dear Registrar General of the Uganda Registration Services Bureau, distinguished representatives of ARIPO, corporate party, that's ourselves, members of the media, ladies and gentlemen, before handing over to our expert, I would like still to do some words and thank you for allowing the AFRIPI program to organize the intervention of two distinguished expert witnesses at the very start of this expert meeting that prepares next week's diplomatic conference. As you know, AFRIPI is a Pan-African program financed by the European Commission, the European Union, that aims at strengthening IP rights in order to foster and better exploit African innovation processes. Copyright is an intellectual property right that has, in our opinion, a major importance in Africa. With the influence and reach of African artists and creatives, now global due to social media and digital streaming services, the continent's creative sector is gaining momentum and major interest. That is why there was no doubt that we would support our partners from ARIPO when they informed us about the project of a protocol on voluntary registration of copyright. As the Attorney General of Uganda already pointed out in the beginning, the Berne Convention contains a prohibition of formalities for copyright protection, which is the result of a historical process. It was during the 1908 Berlin revision of the convention that the current principle of formality-free protection, reflected in Article 5.2 of the present Paris Act, was introduced, according to which the enjoyment and the exercise of copyright shall not be subject to any formality. While respecting the principle established in the Berne Convention, several Berne Union member states have established voluntary national registration systems for copyright and sometimes also for related rights. In the view of those member states, registration facilitates the exercise of copyright and related rights by providing right owners with a simple and effective means to clearly establish authorship and or ownership of the rights. National registration and recordation systems often hold valuable information on creativity, both from a legal but also from an economic standpoint. Registration can also help to delimit the public domain and consequently facilitate access to creative content for which no authorization from the right owner is needed. The information contained in national registries may constitute a repository of cultural and historical heritage, as they represent collections of national creativity, including works and other creative contributions. Now, both Hungary and Spain are countries in Europe that have created systems of voluntary registration. We suggest that it will be useful for the delegates of this diplomatic conference and for the experts that are here in this room to be informed about the experiences of these two countries with their national systems. I'm grateful that the two following experts have accepted our invitation to address this distinguished audience. The first intervention will come from Peter Labodi, who is the head of the copyright department of the Hungarian IP office. He is a copyright expert with a long experience not only in the public sector, but also in private practice. He's currently the vice chair of WIPO's Standing Committee on Copyrights and Related Rights. And the second expert is Professor Raquel Xalabarder. She is a professor for intellectual property at the Open University of Catalonia. She is a renowned expert on copyrights, and currently she's also the chair of ALADA, which is the Spanish Literary and Artistic Copyright Defense Association. Now, allow me to hand over the floor, the virtual floor, to our colleagues, first from Hungary and then from Spain. So please, Peter, if you can hear me, go ahead. Thank you very much.
line would help me. Okay, thank you, I guess. Okay, so thank you very much for the floor. It's a real honor for me to be there, and I'm really not happy that I could not join you physically there, but due to the COVID pandemic and all these circumstances, now it couldn't be done. But I'm really grateful, and I would like to greet all the guests of honor, all the honorable guests, Registrar General, Director General of ARIPO, and would like to condemn you on the progress which you have on the voluntary registry systems. I would like to outline a few details of our system and some experiences which we have. I hope that we will provide some information which could be valuable for you. I think already what I know from your plans and on the registry, you might have some more developed ideas at hand, but I guess maybe some experiences could provide some help. First of all, I would like to share my presentation. And I've got 20 minutes, so I don't think I will take many time on each slide, but I'm sure that all the information there could be handed to you, so you can also read it. And in case you have further questions, I would be happy to answer them. So, of course, when we start to talk about registration system in copyright law, we have to outline the basic principle that, of course, there are no formalities, which has been heard so far today as well. And this is based on international copyright law. So I don't want to dwell too much here. It's just that we are also coming from this framework, of course. Therefore, our system also is voluntary. So there's no, it's not, nobody's obliged to register any kind of works. But as you will see, it has some merit to do so. So first of all, the legal effect of our registration is that it provides an evidence that can be used to prove that a work existed at a specific point of time in a specific state. So this could help, for example, in a legal dispute on the enforcement of copyright. The originality of the work can be compared maybe to a later work, and in such a case, it's good to have this tool, this kind of evidence about the work. But the next thing, I think the major legal effect of our system is that it establishes a rebuttable presumption of authorship in our system. This means that, of course, we also come from the basic principle from the Berne Convention that the person whose name appears on the work should be first, presumably, be considered the author. However, on the second level, the person registered in our voluntary system has to be considered the author, but it is on the proof to the contrary, so it's a rebuttable presumption. If there's nobody named on the work, then kicks in our system, and then somebody could come and show that its work is registered in our copyright office, and can also shall provide a document on this registration, and there can be presumed to be a rights holder, the author of the copyright work. And then if there's no such voluntary registry, there's a third layer of evidence that can be provided, and this is when a collective management organization can prove that its member has a work registered at the CMO, then the author could be presumed to be the author who provides such a document from a collective management organization. And then the fourth layer is if nothing from the previous three levels applies, the person who first published the work should be presumed to be the author. So as you see from these layers, the voluntary registry is the second one. It's quite a strong presumption if you register your work. And now we come to the question, who can come to us and register the work? It's the author or the holder of related rights. So actually it's a natural person who comes, who should be considered under a presumption to be the author. And what is important that our office, does not examine anything in this regard. So there's no proof has to be provided from the person, from the claimant who comes to us. So we do not check authorship. It's up to the court later on if something comes up. So it's a presumption. That's an important thing. And there's also a possibility for more authors. If there are co-authors of a given work, they can register themselves together. That's also a possibility, but one author will be in the process and will act on behalf of other authors. And what the application looks like, what anyone could come to us. It's the application, of course, has certain data which are very necessary to include. It's the name of the author, which is, I guess, is not a surprise. It's also the title of the work that has to be registered, and the type of the work as well, which you will see is quite interesting from the point of view of seeing statistics, what kind of works are registered in our office. There's a possibility for the claimants to also decide whether they want their data to be published. In such a case, in the voluntary registry, we provide in an online database all the data of the voluntary registry, but the claimants might also choose that they don't want to appear in this database. It's up to them to decide, and the office, of course, considers this when we publish these data. But we have on our website a source to this, a link to this registry, so anyone can search in this and can check whether the given work is registered or not. And of course, what is very important, that a copy of the work also shall be submitted to our office. As you will see, there are two basic ways of approaching us. One is the old school, so to say, physical way, and we also introduced an online way as well. In both cases, the copy shall be submitted to us, but in neither of these cases does the office keep the work. So we never keep it in our registry, neither in physical form, neither in digital. So we just provide the document, a seal of this registration, and the work is not kept in our office. So as I already said, there are several ways to come to us. The whole service started in 2006, so it was 15 years ago. There was at the birth of this service, it was just like anyone could come to our office physically, provide us the work, and then we registered it and gave it back to the applicant. And later on in 2009, we opened up the possibility to send in works by post, even by fax as well, even though I'm not sure whether anyone who is listening to this presentation uses fax these days, but this is also a possibility. And from 2018, we also provide a possibility for online applications. In the case of the physical way, we provide a paper certificate to the claimant or to the applicant, and this is quite an old school way of registering. We put the given work into an A4 sized envelope, then we seal it, and we provide a certificate to the applicant, and this A4 size envelope, which is of course sealed and cannot be opened without having any kind of harm in the seal, can be later on used in a court procedure. But the problem with this is, of course, that once you use this evidence in a court case, you basically destroy it at that moment. So later on, you cannot use the certificate. In any case, of course, in a court procedure, the records of the procedure or the sentence or the judgment can, of course, have some document on the work or whether it's copyright protected, but so it can be used later on for proving authorship. But the evidence as given by the office cannot be used later on. And in this phase, or in this context, you will see that the e-certificate, that the online certificate is much better, because of course in the online environment, the use of a file can be done, endless till the end of the world, actually. So here there's no problem with the poverty force. In such a case, the applicants send in by email or by an electronic system the work in a file, and we seal it in an electronic way, provide a timestamp next to it, which will prove the exact time, the exact second when the work was submitted to us, and it also provides a proof that it cannot be changed in an electronic way. So such a e-certificate can be used later on in court procedures or wherever. Now some data on the length of the procedure. We still provide the possibility to come to us with the works. In such a case, we at that moment provide the certificate. As I said, we do not check whether the author is the person who files the application. We do not check whether the given work is copyright protected or not. We do not keep it, so we just give it back in the envelope. And in the case of post and electronic procedures, we have 21 days to deal with the case. This comes from the general framework of the administrative procedures. So actually, we finish with these kind of procedures in much less time, so in just a few days. But this is the basic deadline which we have. A few words about the administrative fees. We charge 5,000 Hungarian forints, which is equivalent to $16 US. And just for comparison, we have there's the WIPO proof service now, which is not much more expensive. It's $20 US, and the US Copyright Office's services, as you can see, are like $45, $65 dollars. So they are basically on the same level. Of course, in the case of the US registry, there are much more services provided, and the procedure is lengthier and more. It's not as simple as ours. So it also reflects in the prices, I guess. We also have a possibility to withdraw or to cancel the data which are registered in our voluntary registry. The main difference between these two procedures is that the withdrawer comes voluntarily from the applicant. So if the applicant decides later on that the data in our registry should be changed or wants to withdraw from the registry, then it can do so. In our 15 years of service, only 16 cases happened, only 16 withdrawals took place. And there's the other procedure, the cancellation procedure, where the court itself establishes that the registered data are not correct. So the author is not the one who registered the work, and it turns out to be coming from a judgment. And then with the judgment, a claimant can come and can turn to our registry and ask for the cancellation of the data, which we, of course, then we act accordingly. But no cancellations have happened so far, so it's not a very regular case to use this procedure. And now some statistics about the voluntary registry. So as you can see, all the 15 years are here, and maybe what you see for the first time, there are different colors. The difference in the colors means that the green one is the analog way, the physical submission of applications, and the blue ones, which are growing now, are the electronic applications. So as you see, roughly in every 5 years, the number of applications multiplied. So when we started the whole service, it was like 150, and then in 2011 it was 435, and then in 2015 it was already 850. And as we see now, we are about 1,000 cases each year, which is not a high number in our view. But as we see, the electronic the number of electronic applications is rising. So we have some kind of um, 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 we're looking forward to more applications here. And then if this service on the electronic way of processing this service will be known much more than we can expect, I guess some raise in the numbers. But in the last 5 years, it's about 1,000 yearly. So it's quite interesting that's the general number as we see it these years. And what is I think very interesting is the type of works which are registered. And what is obvious on this chart is that the literary works are the biggest number. So the double of the rest of the works basically. And then we see softwares which are quite popularly submitted to us, and then motion pictures, designs for technical structures. You might try to understand how for example, a software could be put into a paper envelope, where the solution is that we also allow digital carriers to be submitted to us. So if you come with a digital carrier which holds the work, a copy of the work, this can also submit it to us, and then we put that carrier into the envelope. In the case of online users, of course, a file can be submitted easily. But in literary works, of course, it can be done on a printed paper way, but of course by a carrier as well in these cases. So these are the numbers, and now maybe to sum up some pros and cons about our system. So maybe this could help you in further developing. What is good in this service is, of course, that it's very fast. As you can see, it is done immediately or in a very short term of time. It's quite cheap, and what is good that we do not only provide a proof by this sealed document that it existed at a specific time in the past when it was submitted, but of course the legal presumption which is provided to this registry is very important, so that in the court procedure you can use it well. Of course, the court has to presume in such a case that you are if you are registered in the voluntary registry, that you should be considered upon contrary proof to be the author. It also provides legal certainty when negotiating business. We see there our clients are happy when they can prove this kind of registration, and of course this also links to some negative effects as well, that there's some kind of misunderstanding of copyright law coming from this voluntary registry, because people tend to think that unless something is registered, it's not copyright protected. So this is our work to make clear that it's not the same thing. And of course, it also helps in the search for right holders. We have a problem in Europe, of course, but it's not only a European problem, about the orphan works, such works that where the right holders cannot be identified. It's a good way also to check maybe the right holders link to the work that is registered. It's good for licensing purposes as well. Of course, in a case of quite low number of registered work, it's not the biggest asset, but still it's something that can be used. And maybe some negative aspects. Of course, there's a level of uncertainty regarding this registry. As you might remember, we do not store the works. We do not update any data. So if there's a change, of course, the authorship cannot be changed, but there are some other data that can be included, and we do not follow with the registry these kind of changes. We do not verify the applicant, so it might come up in a later stage that somebody wrongfully registers a document, and then this could, cause problems which has to be dealt with in a court procedure later on. And of course, there's also this that we do not examine the eligibility of copyright protection. So basically, anything could be submitted to us, and later on, somebody could rely on this kind of registration, even though the copyright protection is not granted to the given work because of something, it's not original, or I will not go into details, because of course you are we all know all these conditions. And of course, the locality of this service is also some kind of backdrop, because of course it's a Hungarian legal presumption. So if you want to use this in other jurisdictions, then only the first part of this proof can be applied in a procedure that it existed at the point of time of registration, but the presumption is not coming from other laws. It's based on Hungarian copyright law. And what is a big lack of our service, and where we want to develop it, is that we do not have digital identifiers attached to the work. So in the online environment, our registry cannot be used in a whole extent. And this is a real handicap which has to be dealt with. Of course, in our online environment, it would be the most important to have this kind of information attached to the works so that they could be identified in the online environment. And what I already mentioned you is this misleading effect about copyright awareness, is that you always have to emphasize that this kind of voluntary registration does not constitute any copyright protection. It just helps in enforcing the rights of the right holders who want to live with their copyright protection or the rights based on that. So actually, this was my presentation. I hope I didn't take too much time, and could maybe provide some information worth listening to. And would like to wish you all the success in your future negotiations. Thank you.
Thank you very much, Peter, for that very insightful presentation. I'm sure that Uganda relates, because in Uganda today we have a voluntary system of registration, and I believe that the things he was mentioning somehow, in one way or the other, have really either affected us or we have seen them in our practice. We'll be having a couple of questions asked, but there's a slight change of program. I would like us to go for a photo shoot, even before the Q&A. And then right after the photo shoot, we'll have a break tea. And then when we come back, we'll have the Q&A for Peter's presentation and also the subsequent presenter, if that is possible from your side. The break would be about 30, 45 minutes, and then we can resume thereafter.
Sure.
This is a call to our online listeners who are on call, that will be having a break for 45 minutes. And then we'll resume. We'll have questions for this presentation, and also have the subsequent presentation from Spain.
Recording stopped.
Okay, so the team at the entrance, you are going to help these people to lead them to the right place where we're supposed to have our photo shoot, and also we'll be guided on where to have our tea from. Thank you so much.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends, the world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. The climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you'll have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset. From the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you'll only see.
Okay, let me request us to take our seats, please.
Because to truly
I'm
know
sorry, there
and
was
appreciate my
a bit of a hiccup.
you will have to see it for yourself.
We have had to rearrange because our online presenter has been waiting for us for the last 2 hours. And so it's only fair that we listen to her and then we carry on. I do not know how this is going to affect our other participants online who probably could have logged off following my earlier announcement, but I hope that we were able to get in touch with them and let them know that we're back on. So let's take our seats, and then when she's ready, she'll get onto the call. Our online team, are we on? Could you please play for me the online screen? Oh, great. So once again, very, very sorry for the hiccup. I hope that this remedial action will be of some value. Professor Raquel, are you on call? Can you hear me?
Yes, I am.
Wonderful. Thank you so very much. Ladies and gentlemen, let's listen to Professor Raquel.
Recording in progress.
From the Spanish Voluntary Registration Office. Ms. Raquel, carry on, please.
Well, thank you very much, and I'm terribly sorry because I think I left you without coffee. I was far from my intention. I would have been also very happy to wait until the coffee. But anyway, thank you very much. Thank you, ARIPO, for inviting me to participate in this event regarding this very exciting project, a protocol on voluntary registration, right? I'm delighted to be here and to contribute after the excellent and very rich presentation done by Mr. Labodi from Hungary. I will simply add a few comments. I do not have a PowerPoint, but maybe I can craft a few information that I can share with you afterwards so that you can use it if necessary. Basically, my intention would be in the 10-15 minutes that I've been asked to contribute with some comments on the specific issues for the Spanish voluntary register that you will see. There's a few important differences from the Hungarian system, which I was not aware of, and I have learned a lot thanks to this presentation, and also perhaps share a few issues with you or ideas with the intention to contribute to the debate. So let me start with a couple of ideas regarding the context, right? This Article 5.2 of the Berne Convention, the idea of no formalities and independence of protection from the country of origin. As Mr. Schneider was reminding us at the very beginning, Article 5.2, this principle that no formalities will apply and that the protection is independent from the existence of protection in the country of origin, was not always there. It was not in the original 1886 Berne Convention Act. It was only introduced in the Berlin Act in 1908, if I'm not mistaken. So the original Berne Convention article, it was not an Article 5.2 as we have it now, not even a 4.2 as it was introduced, but the original text of the Berne Convention did quite the opposite. Then the principle of national treatment, the very basis of the Berne Convention, was only available when the author had fulfilled or accomplished with the conditions and formalities prescribed by the law of the country of origin. So conditions, originality, substantial requirements, formalities, anything that has to be complied with, any formality, any form, any procedure, right? Prior registration, deposit, copyright notice at the first publication. And many countries at that time, that was the 19th century, required these formalities. So let's all be aware that the beginning of the Berne Convention, we were sort of, the umbrella accepted formalities in the country of origin, and that was the requirement for that work to be protected in other countries that were part of the Berne Union, right? We soon realized that these formalities were becoming an obstacle for the international protection. So you fail to comply with any formality in your country of origin, and you cannot have protection anywhere under the Berne Act. And that's where we ended up creating this principle. Let's get rid of formalities and let's make protection, international protection, independent, completely independent from the country of origin. So these two principles are very important and they go together. But let me just point out that another thing that very much explains the situation we have in Spain. Article 5.2, when introduced in Berlin, does not prohibit public registries, does not prohibit formalities per se. It prohibits that these formalities apply to non-domestic works for the protection of works from countries of origins that are other Berne Union countries when they want to be protected outside of their country of origin. So to put it bluntly, if you let me be, national works remain subject to national law, and this national law may require formalities. So we usually say Berne doesn't allow for formalities, but let's be careful. That doesn't allow for the compliance with formalities to have access to international protection under Berne, okay? And this is precisely why Spain, despite being one of the original signatories of the Berne Convention in 1886, Spain had a registry of intellectual property, we call intellectual property copyright and related rights, since 1880, since the end of the 19th century. And we maintain that registry as compulsory, constitutive, and non-registered work was not protected in Spain until the 20th century, until 1987. And we managed to do that because this registration, the compliance with this registration, we were only applying it to national works, to works of national Spanish authors or first published in Spain, right? It was in 1987 that we crafted and approved a modern law of intellectual property, of copyright, and we accepted also for Spanish works the principle of automatic protection. And then what we did was something that other European mostly and other national, other countries had already done. Instead of demolishing the registration system, we kept it. We had a 100 years old registry, a very important asset for culture, for, to assess the national culture, and we chose to maintain it, but as a voluntary registration. So now we have the central registry, the unique single registry, which is over 140 years old, but which is managed in a decentralized manner. And this is very important also to bear in mind because we sometimes have discrepancies between different decisions by territorial registries. 11 territorial registries, which are managed by different autonomic communities in Spain. And we have a coordination commission that gathers all the IP registers to unify criteria. So here's an important difference from the Hungarian system, the teenager Hungarian system, if you let me say. We have a very old system. I was picking up some numbers. We have some 27,000 new registrations per year. That's the data of 2019. 75% of these 27,000 new registered works and productions, you'll see 75% amount for literary works. So literary works are the big chunk of registered works. 95% of the registrations are claimed by authors directly, but as you will see, this is important to bear in mind. And if you want something a bit also important nowadays, mostly by men. 2/3 of the registrations of these 27,000 registrations are claimed by men. So let me go quickly. What is registered in Spain? As in Hungary, we register works and we register productions, related rights, performances, phonograms, audiovisual recordings. But what we register is not per se the work, the production, it's the ownership of rights, and very important. Of course, the author is identified as the author in the registration, but the registration system only cares about exploitation rights. And this may also be explained because of the over 140 years and history that we have of the registry. Ownership of exploitation rights, we do not, the registration has nothing to do with moral rights, has nothing to do with a statutory remuneration, and even has nothing to do with authorship. Authorship is there because it conveys who's the owner of the exploitation rights. But, authorship is just, we could say, an input to decide who's the owner. It's a public registry. It does not mean it's a full public access. Unlike the Hungarian system, we do keep the work. A copy of the work has to be attached with the application, but we do not show the work to everybody. Actually, the registration, the title, the description of the work, who owns the rights, which rights are owned by who, the publication date, this is all of public access. Anybody can apply for a certificate and he will get the information. But access to the work, to access the work, what we call the administrative file, you need to have a legitimate interest. And even when we're dealing with anonymous works, that's only the one whose claim was registered as the author who could have access to it. So public, but not so public. A public, but not access to the public, all of it. But we keep a copy of the work, unlike in Hungary, right? It is, and that gives also problems sometimes to, storage incapacities. And imagine we have a very historical system, so that gives us some problems too. It's an administrative procedure. It may be done online or at the offices. It's subject to administrative law. The public fee is some 13, 14 euros, so more or less what the Hungarian system was also applying. And the forms are standardized, regardless of which territorial registry you apply, the form is always the same. The registrar, who is the one who's going to be, resolving, providing a conclusion to that application of registration, has 6 months. And this 6 months is very much an administrative process. So maybe he can require more information, and then the 6 months are paralyzed. And very important, the author or the owner, the original owner, may choose which territorial registry to go. You may be residing in Barcelona, but I choose to register at the office in Madrid. It's a single unique registration system. So it doesn't matter where you go, but it does matter because sometimes in very specific issues, different registrars, different territorial register may have different criteria. What is protected, what is not, the level of originality. Because unlike in Hungary here, the register does look into the work. Of course, he has a very weak position, right? But he does look into the work and decides. Who can register the rights? As in Hungary, the authors and the original owners, the performers, producers, broadcasters. Also, derivative owners, when there's been a transfer of the copyright or of some rights in an inheritance of the copyright, that can also be registered. What we want to know is who owns the rights on this work or production, and a private contract. In the old times, we used to require a public document done by a public notary, but we also realized that that was, it was a deterrent for registration, so we have abolished that. Specific requirements are set for complex works and productions. Think of joint works with several authors, audiovisual productions, derivative works. So the register needs to be convinced that this is a work and the person claiming to be the owner is indeed the owner. I'm not going to go into detail here. If you want, we can go into detail in the debate because I'm running out of time. So what is the effect of a resolution? The register looks at the work, says, yes, this is a work. Yeah, the work exists. This is what we call a qualification. There is a work, and this person owns the rights in this work. The exploitation rights, let me be very adamant on that. As in Hungary, this is we call it a iuris tantum presumption. It's rebuttable, so it's only prima facie, right? If we're going to use Latin words. As long as nowhere contests that this is true, the register has said that this is true. This is the facts. This is reality. So unless proven to the contrary, the work is a work or a production, and the rights in this work belong to the person who the register says is the owner. But bear in mind that the register is in a very weak position, right? She can be lied at, so he or she looks at the work. She thinks, yeah, there's, this is original. There's a minimum threshold of creative input. And I believe that this guy, this woman, is the author, therefore, first owner of this right. So there's this qualification, this examination, but with very limited facts. The register may ask questions, may say, oh, give me a declaration that you are the author. She's not convinced, but she may be easily lied at, right? So that's why anybody can go to court and prove, a civil court, and prove that this is not a work, that this is not original, that this has been copied, that this one is not the original authors. So rulings by the register denying registration, but also confirming registration may be appealed at a civil court, right? And in Spain, we have experience of different resolutions by territorial registries that have been confirmed or reversed by courts. Bear in mind that often the very concept of originality is a very elusive thing, right? What is original, what is not? What about a smiley face, as an emoji, a little bull or the shape of a donkey or a bull? What is original? And we often have different territorial registers that may have different, that's why the coordination of these registers is very important. But sometimes also in a very generic manner, not only for a specific work that has been registered, but also in a very general manner, courts tend to provide criteria as to what is original and what is not. Think of, for instance, in the European Union, the Court of Justice recently came with this very clear prohibition to apply a higher level of originality, to require a higher level of originality, of creativity, to the protection of works that could also be protected as designs, right? The Coffinal decision, the Brompton bike. So these were things that we were doing in Spain and the registers were doing, and now we have to change because there's general jurisdiction and jurisprudence leading towards another direction. So just to wrap up, I'm sharing with you the Spanish historical experience with all the good and all the bad, the problems it entails. But I would like to just point at 3 issues when you go ahead with this very interesting project of a voluntary registration system with an international scope, okay? Be prepared, I would say, for different concepts of originality, different works under different laws. And this is something that Berne Convention is very comfortable with, okay? Regardless of what is in the country of origin, is it a work or not, we're gonna protect this work, if it's a work, under other different Berne Union countries members. So laws may be different, and also the interpretation of a similar law, the interpretation by national courts may be different. And the text sometimes says the same, but the courts interpret it differently in different countries. So be prepared for that, and let's be comfortable with that. Be ready, I would say, also to face a daunting issue, which is applicable law and jurisdiction. Applicable law, which is applicable law in copyright issues, that's something that Article 5.2 of the Berne Convention doesn't solve completely. So you would have probably to deal with, the idea of someone in an African country registering the work in another African country. And this is voluntary registration, maybe because that country is more favorable to registration than the country of origin. And that should, I think, always be allowed, right? And perhaps a third issue, be vigilant, but you were saying that already, you were all agreeing on that. We should be vigilant that this voluntary registration system does not end up having constitutive effects, but in a non-expected manner, right? As voluntary registration is okay with the Berne Convention, of course. Anything that adds protection to authors is welcome, Article 20 of the Berne Convention. But let's be aware that it does not have indirectly and unexpectedly any negative effects on the Berne Convention minima. And let's remember that the Berne Convention minima is that not only independence of protection, but also that regardless of what happens in the country of origin, the work may be protected independently in other countries of the Berne Union, right? So I wish you all the best with the project, the very interesting and thrilling project of voluntary registration. There's a lot of good things to be said about the voluntary registration of copyright, and anything that works in favor of providing and fostering the protection of works also at an international level should be welcome, I think. But that was a few ideas. I'm sorry because I went over 5 minutes over my time that I was allowed, but I just wanted to share these few issues with you.
Thank you so much, Professor. And that was an applause, but I would request that you put on the microphones and then you clap. That's when she'll hear us, I guess. So just put on the microphones if you can. Thank you so much. Sorry about that again. Professor and... Okay, sorry about that hiccup. Again, technology is not our very good friend sometimes. But I would like to say thank you very much, Professor Raquel and Peter, for your very good presentations. I'm sure that they have given us insights into what we should be looking about when we talk about voluntary registration of copyright. Now, I will not go into any detail, but I will invite the experts who are here with us and those online who have any questions, comments to make, to please raise your flag if you are here physically, but also raise your hand if you're online, and we shall pick you and you'll ask questions concerning the last two presentations from Peter and Professor Raquel. You may proceed. Oh, Kenya, please. Thank you so much.
Thank you for the opportunity. Thank you for the two wonderful presentations. I had a question for the presenter from Hungary. He talked about, I noticed in the works, the registrations, the highest registrations were literary works. I didn't see anywhere musical works or sound recordings, so I don't know if that is part of what they do with the registration with the types of works. I would like to know that, whether they have any musical works that are registered, or maybe they're categorized differently. He also talked about the issue of having more than one author. I didn't get it clearly whether when you have more than one author, one person registers on behalf of the rest, or then you register with more than one names. And if you register with more than one names, do you have a maximum? Say if we have 5 authors of a work, are you going to pick author X to represent the rest? And do they need permission, authority from the rest? Or you're going to have in your register 1, 2, 3, 4, 5 as the authors? Thank you.
Thank you, Kenya. Do we have any other question from the audience? As they think about the questions, let me also read out questions from our online listeners. One says, is there any case you have defended on voluntary registration? What was the type of case? I guess this question goes to both presenters to share with us their experiences. Is there any case that you have defended on voluntary registration? What was the type of case? The other question is, how much revenue do you get per year from voluntary registration? Again, it's an open question, and I guess we'll share experiences from Spain and Hungary. We have another question from Uganda. Professor, you may go ahead.
Thank you very much. I just want to pose a question to either one of the presenters, how they have handled collective management organizations or collecting societies through the voluntary registration systems in their regions.
Thank you, Professor. I think we should take responses from Peter and Professor Raquel. And then if there are any other burning questions, we can take them on before we go for the break. Over to you, Professor and Peter.
Professor, shall I take the floor first?
Please go ahead.
Okay, thank you. So thank you very much for this interest and for all the questions. The first question was about the musical works. Indeed, the number here is quite low, but there are a few applications here as well. I will maybe try to show you once again the chart here. Yes. So actually, here, this is the musical compositions here, but this is the recorded performances, but the programs are quite low. And this actually is due to the case that there are CMOs acting here. So the members of CMOs, of collective management organizations, are taken care of by the collective management organization. So, and in the case of music, the collective management system is rather developed in my country. So therefore they rely on the CMOs here. As for the question on the co-authors, yes, indeed, you understood it well, that there is a possibility that not only one author registers the work. In such a case, however, there is one designated author who is chosen by the authors. There's no maximum number here, so it could be like 5, 10, or any number of authors, and they provide a mandate to the author to represent them in the procedure. And in the voluntary registry, you can see the data. There is the name of the work, the type of the work, and in some cases there are several authors listed there, so they all appear according to the applications. You might remember that there were some data protection issues here, so there might be a case where the authors do not want to be listed in our public registry. In such a case, of course, we only to mention them. As for the income, as you might recall, we have roughly about 1,000 cases each year, and I just tried to make a fast brain calculation here, multiplying it with the 5,000 forints, which means like 5 million Hungarian forints altogether, like 15, 20,000 US dollars. So it's not, so to say, the most, the biggest income of the office. As for the, I'm not sure whether I quote properly the question, but please correct me if I didn't make it. It was if there was a negative case on the registry, whether there was some kind of example when the registration was tested. I recall one case which was also in the press, and it was quite interesting because this was basically related to the misunderstanding of the registry. That there was a very famous method of teaching through guitar playing people in need or with certain mental issues. So there was this kind of method which was very popular. And at a certain point, one of the members of this company who were providing this service came to the office and registered the method as such in our registry, and later on claimed that the rest of the people should not be able to use this method because it's registered under the name of this person. So he holds the copyright, and no one could rely on this protection anymore. And that was an opportunity for us to clear properly in the press as well that this is not something where you can claim all the rights, but there is a presumption which could be tested at the court. And of course, in this case, the procedure as such is not something which worth copyright protection, as you all know. So no rights were coming from this kind of registration. So this was quite an interesting case, I think. Thank you. If I didn't answer you well, not the right information were given, then please just let me know. Thank you.
Thank you, Peter. I think you've done exceedingly well. Let's hear from Professor Raquel, please.
Yes, I was trying to put a bit of information and put together all the questions. Regarding the amount of money collected, I was doing a very rough calculation regarding new registrations. Remember that if you register a work, you pay a fee, but also if you want to register a transfer of ownership, you also pay a fee. It's a smaller one, but only with the registration, right? It's 27,000 per year, some 13, 14 euros. That would give us all over Spain some 378,000 euros of revenue, right, for the register. Another question was musical works. In Spain, this the information I have, I was saying 75% of literary works, 14% of musical works, less than 2% of audiovisual works. And the rest is, you know, productions, performances, and all the rest. So a very big difference depending on the kind of works that are being. Connection with the CMOs. This is something that in Spain, you know, the register needs to be convinced that you are the original owner, hence that you are the author. Authorship implies, results in original ownership. You may go to the register and show that you have registered that your musical work with a CMO. But the register doesn't need to take that registration in the CMO as you know, on face value, that we call it. If he's not convinced by what you tell him, he's not bound by the CMO registration. Remember that the CMO registration is a private contract between the author and the collecting society. It doesn't have any public appearance. It doesn't have any prima facie value of anything. It is at the same value that may have the presumption of authorship in Article 15 of the Berne Convention. This is the work, and I have published it with my name. Yeah, well, unless somebody else proves the contrary, you know, you may get away with it, but that doesn't mean you are the author. So when the register has to make this assessment saying this is a work and you are the author, he needs to take into account all the facts that he has at his disposal. That could be the publication with his name, that could be the registration in a CMO, but he's not bound by this, okay? This is just presumptions. He's bound by what you're telling him, and when he looks at in your eyes, or when he requests more information, if it's done by online or over the phone or whatever, he's convinced or not. Multiple authors, usually what we do is the register says, yeah, the question was, one author may register the full work. Yes, yeah, if it's a joint authorship work, right? A work of collaboration. But the register will ask, who are the other authors? He wants to have the names, even the percentages of the other authors. So one may act on behalf of all, but the registration needs to explain clearly who are the authors, all of them, no number, it could be 27. And if it's a joint work of collaboration, they all should be there. And with a percentage, if possible, if they had agreed to any percentages, they should be, because that's precisely what the registry wants to have. Who owns what in what percentage, right? Other issues apply for works, for instance, audiovisual works. I know that once a producer tried to register an audiovisual work in the Barcelona registry, and in Spain, audiovisual works are joint works, works of collaboration. So the producer only owns the right in the audiovisual work that have been granted by the authors, by the co-authors, right? The script writer, the director, and the music composer. So the registrar said, I know you are the producer. I know you are the original owner of a related right. So I can register the production, the audiovisual production. But in order to register the audiovisual work, I need you to prove to me that you have been transferred the rights from the copyright original owners, the authors, the co-authors. It's basically a matter of providing enough information to the registrar that he's convinced that when he is stating a fact, and this fact is going to have this prima facie, right? This prevailing value, a juris tantum value, he wants to be convinced of that. Or for instance, we have a system of a presumption of transfer of exploitation rights in a work created under employment in favor of the employer, right? So when an employer, a businessman, right, a corporation wants to register a work that has been created by one of its employees, the register wants to have a declaration of the employee saying that, yes, I have created this work and I have created it under employment by this company. And then the register registers the work as initial author, initial owner to the employee, or derivative owner to the employee. But it's a very weak but also very powerful position, right, to be a register of copyrights. And specific cases we have had in Spain, for instance, maybe one that I don't know if you might be interested, but there was once a bullfighter, right, this is big in Spain, in some areas of Spain, tried to have his, what he called faena, his bullfighting performance registered as a work, not as a performance, but as a work, right? And the court, the registrar says, no way, there's no originality in doing a bullfighting faena, as we call it. Well, it's difficult because if I translate it as work or I translate it as performance, but no, bullfighting is not original. And the bullfighter went to court, and the court confirmed that that was not a work. Okay, maybe one day they'll try to say, what about a performance, right? That might be a different thing. But so far, we have plenty of cases of denials of registrations that have been confirmed by courts. Not so much perhaps confirmation, registrations that have been taken by somebody else to court to prove the contrary. But I'm sure there are cases also like this, perhaps more rare. But and usually the registrars are very, very strict. If they are not convinced, they do not register. Also because registered or not doesn't make a difference, right? So that's something we need to be very, unlike in Hungary, as I was hearing or learning today, I think the Spanish system is a bit more restrictive, but it's voluntary. So even if the register says, no, this is not a work, you may still consider it protected as a work, and you may enjoy protection without registration, right? So.
Thank you, Professor. Professor, could you please also throw light on how you handle applications that compromise moral values of a given jurisdiction?
Moral values, interesting, that one. In principle and in theory, I cannot speak for all the registers, but I think that this would be the case. The registrar does not make any moral judgment at all. He should not be. Spain is an there's a principle of freedom of religion. So in theory and in principle, and I think that in fact, registrars do not apply any moral or religious or even political judgment in it. They should only assess the existence of originality in a subjective or objective manner. That's where we may have a bit of differences, but no moral judgments. In fact, I have it's more an anecdote, but it's a very nice anecdote. There was once, the registrar in Barcelona is a friend of mine. I know many of these cases through him. He once had a very, let's say, delicate problem with an old lady who came to him and said, I have composed this poem tonight because the Virgin Mary was dictating me the poem. And she wanted to have the poem attributed and owned by the Virgin Mary. So it was very difficult to try to convince her that the Virgin Mary was not the author, that she was the author of that poem if she had been the one, who came up with these words. At the end, the only way to convince her was that she had a formal problem, which is that she didn't have the national registration number, identification number of the Virgin Mary. So there was no way he could register that work to the Virgin Mary's name. But you do have works that if that lady wanted to have this poem registered to her name, regardless of the content of the poem, which was a religious poem, that would have been no problem at all. But then, of course, you need to have an author, and you need to convince the register that you are the author. And that author is a human person with a national registration number.
Very interesting. In a word or two, can a person register a foreign, can a foreign right holder register directly a work in Spain? Just in a word or two.
Yes. Yes.
Great. And
yes,
this goes to Peter. There's a question from Rwanda. The person is saying, can institutions register in Hungary? He says that, or she says that they heard you say that a natural person only can register. So can institutions register in Hungary? Peter, please.
Well, it's a difficult question because it's not excluded that not only natural persons can register. So it's also up to legal entities as well. But if we come to who can be considered an author, then our copyright rules are quite strict that they should always be natural persons. So in the case of softwares, sometimes there are this joint authorship, and sometimes they come up that the company which the software developer company registers. But of course, this would not mean that the company itself should be considered to be the author, but of course the person who are in the company. Thank you.
Thank you so much, Peter. And Mr. Laterio Paolo of WIPO would like to know if a foreign right holder can register directly a work in Hungary. In a word or two.
That's right. Anyone can. There's no exception. So anybody could turn to us. Of course, in such a case, I would presume that there would be an online process, but it's absolutely possible. Thank you.
Thank you so much, our dear presenters, Peter and Professor Raquel. We thank you so very much. We can't thank you enough for those very insightful presentations, and of course, the discussions that came along. We would have taken more questions, but in the interest of time, it's not going to be possible. What I can promise is that we shall share your contacts with our listeners today, and maybe in a day or two, you'll be hearing from them, asking questions for you to further give clarity on a number of issues. Ladies and gentlemen, I want us to give a round again to our two presenters. I hope that Peter and Professor Raquel can hear that. People are excited about your presentations, and thank you so very much once again. I would now like to invite us to a cup of tea. And it is going to take us about 30 minutes. But if we use less, so much the better. The team at the entrance is going to guide us where this tea is. Let me request once again that we try to maintain time. It's not our best ally today. But, well, since we are here, we shall determine how it goes. Kindly, the ushers guide the team where the tea is. To our online listeners, we'll take a break for 30 minutes. You could also grab a bite as we prepare for the next presentations. I thank you so much.
Record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it.
Recording stopped.
Because to truly know and appreciate my story, You'll have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset. From the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you'll have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset. From the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. The scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world. scenery is different. The vegetation is different. Climate is different. And most of all, the people are different from anything elsewhere to be seen in the whole range of Africa. I say, concentrate on Uganda. For magnificence, for variety of form and color, for profusion of brilliant life, bird, insect, reptile, beast, and for vast scale. Uganda is truly the pearl of Africa.
The world record has been broken by almost exactly 2 seconds. He's Joshua Cheptegei of Uganda.
This is superb running.
I've shared my story with the world, with you, but you've only seen the half of it. Because to truly know and appreciate my story, you will have to see it for yourself. My home, my Uganda. From the breathtaking waterfalls of the Nile to every beautiful sunrise and sunset, from the amazing blankets of green to the priceless treasures that lie within. Along the way, I have met some unusual friends. The world-famous silverbacks. When I see them, I behold Uganda's treasures. So yes, you see me and celebrate Uganda. I assure you, there is a lot more in store. I have lived here for years, but even I am yet to see its full glory. Join me. Let's take on the Pearl of Africa together.
Uganda is a fairy tale. You climb up, and at the end, there is a wonderful new world.
May I have your attention, please? Ladies and gentlemen, we are now going into the meat of the day, the expert session.
Vegetation is different.
The expert session, so I would like to request experts to take their seats and non-experts to quietly exit such that we can then begin the expert session. So non-experts, please. I will request that you exit, and then experts will take their seats such that we can begin our expert session. By way of other information, because we have had a late breakfast, I am requesting that we do our lunch at 2. So I have communicated with logistics that we shall have our lunch at 2. Therefore, we are free to have a discussion for the next 1.5 hours in preparation for our sumptuous lunch. I want to invite the chair of the session, Madame Dora Makwinja, to take your seat. And then I will take leave, and you'll take on from there. So thank you very much. As she takes her seat, I will take my leave, and she will invite us to lunch at 2. The team will be outside waiting to show you directions where we'll have our lunch. Madam, you're most welcome, and take on the session. Thank you so much.
Ladies and gentlemen, thank you very much, Vincent, in the first place. And can we get organized so that we start? Because we don't have much time, and there's a lot of work ahead of us, but it will be simpler with your cooperation. So we start with this session by inviting the Secretariat to make a presentation, which will be followed by the presentation by our consultant on the draft protocol. Thank you. Maureen, it's your turn.
Thank you, Madam Chair. Good afternoon, distinguished delegates. All protocol observed. We shall present on the document that was circulated to all delegates, titled Consideration of the Draft Protocol on Voluntary Registration of Copyright and Related Rights. Introduction. The 40th session of the Administrative Council that took place in Harare, Zimbabwe, on 5th to 7th December 2016, identified the need to adopt a protocol on voluntary registration of copyright and related rights under the ARIPO framework, and hence approved a roadmap for the establishment of a voluntary copyright registration and notification system at ARIPO. The roadmap required ARIPO to undertake a feasibility study and to develop a policy framework for the registration and notification system in the member states.
Sorry, Maureen. Forgive my novelty or whatever it is. I'm novel, I'm new to this. But Pierre advises me that we have to adopt the agenda first. It's not here, but they're going to project it right now. So we adopt the agenda and then proceed. So my apologies. Yes.
Noted, Chair.
Yes.
Thank you.
So, Pierre, can we have it?
They are back. I don't know if they're going to be. There's questions.
Okay, thank you. We can see the agenda over there. We had the opening session and then the draft
Recording
program.
in progress.
The draft program for the opening session, and then we had the presentations by our two eminent speakers. And we are now on item number 4, 5, and 6. So since the other two, or the first 2 and 3 have already been carried out, I think we'll proceed to adopt the agenda as is. Do we have any oppositions? Or shall we proceed as the agenda is? Yeah, Pierre, could you please guide? Do we need people to raise hands as in our normal meetings, or should we just say this has been adopted as an agenda, a working document or program? Yeah.
Madam Chair, I think delegates can raise for adoption and secondment, and we proceed. Thank you.
Thank you very much for that guidance. Should we then have delegates raise up their hands, even those that are online? Yes. Thank you. So thank you very much. How many? Yeah, thank you. Sudan, Liberia,
but Chair,
everyone, almost everyone. Yes.
Chair,
Sierra
point
Leone?
of observation.
Yeah.
I think a motion should be moved and seconded by somebody, then we can consider the agenda to have been adopted. Thank you.
Thank you, Sierra Leone. Yes, Liberia.
Madam Chair, having read the agenda put forward for the smooth deliberation of this meeting, I therefore move, if I can obtain a second, that the agenda be used for today's deliberation.
Okay, so Liberia proposes that we adopt. Yes, Zambia.
Zambia seconds the motion to adopt the agenda.
Thank you very much. Anybody who agrees as well? Do we have other delegates? Okay, thank you. Malawi, Sierra Leone, Sudan, and Kenya. I can't see the country name. Okay, Tanzania and the Gambia. Thank you very much. And Zimbabwe, of course. Mozambique. So the agenda is adopted. So then we proceed. We already had, we are on item number 4, which I can't see anymore, but it was about the adoption of the draft protocol. But before we get there, we had started with the presentations by the Secretariat and our consultant. It will be followed by the presentation by our consultant. So I would like to ask Maureen to continue, or maybe you may wish to restart your presentation or continue from where you stopped. Thank you.
Thank you, Madam Chair. The presentation will be done by the Secretariat on the consideration of the draft protocol on voluntary registration of copyright and related rights and its annex, which is the draft protocol. In the introduction, as alluded earlier that during the fourth session of the Administrative Council that took place in Harare, Zimbabwe, they identified the need to adopt a protocol on voluntary registration of copyright and related rights under the ARIPO framework, and hence approved a roadmap for the establishment of a voluntary copyright registration and notification system at ARIPO. The roadmap required to undertake feasibility study and to develop a policy framework for the registration and notification system in the member states. The feasibility study and policy framework were both adopted by the 41st session of the Administrative Council that was held in Lilongwe, Malawi on 20th to 22nd November 2017. During this session, the Council also adopted the recommendation to develop a legal framework to implement the voluntary registration of copyright and related rights and approved the roadmap. At the 17th session of the Council of Ministers that took place in Charlesville, Margib County, Republic of Liberia, from 21st to 22nd November 2019, the Council gave approval for the legal framework on the establishment of a regional voluntary copyright registration and notification system to be formulated into a draft protocol for adoption at a diplomatic conference that was to be held in Kampala, Uganda in July 2020. However, the conference was rescheduled due to the prevailing COVID-19 situation. Further to the decision of the Council of Ministers, the Secretariat engaged a consultant to reformulate the legal framework into a draft protocol, taking into account the input of the member states and cooperating partners. The draft protocol on voluntary registration of copyright and related rights is attached to this document as an annex. Madam Chair, the Experts Committee is invited to consider this document, comment as it deems fit, and engage to finalize the text of the draft protocol on voluntary registration of copyright and related rights to be adopted in the diplomatic conference on 27 to 28 August 2021 in Kampala, Uganda. Madam Chair, I now welcome my colleague to present on the annex, which is the draft protocol. I submit. Thank you.
Thank you very much, Maureen, or Secretariat. Can we now have Mr. Dominic to present to us? Before we adopt the protocol, at least we need to discuss and comment on it.
Yeah. Thank you very much, Madam Chair. I believe the participants who circulated the protocol in advance, the draft protocol. I had proposed to be brief, highlighting the salient features of the protocol. I believe in question time or throughout the presentation, there will be questions asked which will maybe demand that we go word for word on the contentious issues that will be raised throughout the discussion. So, Madam Chair, we found it befitting as the consultant team as WIPO, as ARIPO, to, I apologize, as ARIPO, to hint on the issues which we think may be problematic or throw confusion on the content and purposes of this protocol. So in that respect, we decided that we should start by pointing at the specific features, and in this respect, I'll start with Section 2 of the protocol. I will not be going systematically 2, 3, 4. I'll be jumping 5, 6, 7, and 8 to make my presentation coherent. The objective of this protocol is important to note that it is to facilitate voluntary registration and the creation of a regional database. This appears in Section 2 of the draft protocol. Now, we wanted to impress that the protocol does not intend at all to create copyright. As Section 2 provides, it is merely to provide for the voluntary registration of copyright works that already exist. And it is not for this protocol to determine the circumstances under which the copyright came to exist. We incorporate and recognize, as it will be noted in the preamble, the Berne Convention, Article 5.2, for the protection of works, which provides that the enjoyment of copyright shall not be subject to any formalities. So this protocol is not intended in any way to run counter the Berne Convention. The provisions pertaining to the conferment of copyright will continue to prevail, as the previous presenters did mention. Concepts of originality and the types of work that qualify for copyright will maintain and remain. Now, the other point which I want to highlight is on Section 8.1 of the protocol. There is reference to examination. We thought it befitting to highlight this as well, that examination referred here merely refers to examination of the procedures that the ARIPO proposes to facilitate, in order to facilitate the registration of copyright. And these procedures are stipulated and provided in Section 17. You will see when you look at those provisions that it has nothing to do with the substantive issues of copyright. They merely prescribe what an application for copyright that is going to be submitted to ARIPO or to a competent state, competent authority within a state, shall require. If you go to Section, I say 7, sorry, not 17, Section 7. You will see there an application for voluntary registration and notification of copyright and related rights shall contain the following: identity of copyright holder or related holder, full names, nationality, title of work, category of copyright, the year of production, information regarding whether the applicant is owner, etc., etc. So all these are intended to show, before we get into the actual content of the protocol, that this is not about, we are not about determining substantive issues of copyright. And the examination here only relates to determine whether the provisions of Section 7, whether the application complies with the provision of Section 7 for the application. Now, the innovation that has been brought about by the protocol is the creation of a regional database and registration. We say it's an innovation because in ARIPO because there are other member states here who already had voluntary registration systems in their own countries. All that ARIPO is doing, it is creating.
You see, no, I'm just.
ARIPO is creating a regional database where all the registered works will be deposited. Registration. Now, this is sections 5.2 to 5.3. The protocol defers registration to national states, contracting states. That means that ARIPO is not in any way appropriating the registration functions of already existing states or of other states that are going to be adopting the protocol. The states will continue to do the registration, and as we will see as we go, there will be a process through which that registration will now be transferred to ARIPO for incorporation through notification into the database. But there are exceptional circumstances where the ARIPO itself, and this is sections 5.4 and 5.6, where ARIPO will undertake the registration itself and not only be a repository of notification and provision of a database. Now, these are instances under section 5.4. If we go to 5.4, you see, where contracting state has not appointed a national competent authority within its territory, the contracting state may appoint ARIPO to undertake the function of registering copyright and related rights. So in this particular instance, and it also in, okay, let me limit to this one now. So in this particular case, ARIPO will not only be a repository, it will be requested to provide both the registration and notification. Whereas where national states have their own competent authorities, the national states will provide the registration and then provide notification to ARIPO. Now, it will also be the case where the application is coming from where the authority, the national states have not designated a competent authority, or in the case of a non-member state, ARIPO can, or citizens of non-member states. In those cases, ARIPO will provide registration and notification. Now, the registration process. This is section 7. The protocol describes requirements for voluntary registration, both at ARIPO and at member states. We have gone through those requirements. But the protocol also recognizes the competence of national states. Okay, one of the requirements here is that in section 7 is that the ARIPO has provided these provisions, which you've seen, but there is, in addition, and this is in section 7.4 of the protocol, it recognizes that for registration, and this is in national states, each state is allowed, has the competence to make additional procedures within its own state. So ARIPO prescribes these procedures, but states continue to have the latitude to have additional procedures to those in ARIPO. Now this is going to come, this will be important when ARIPO examines the applications. Because where ARIPO examines applications which have been filed directly with ARIPO under the circumstances that we've already mentioned, in that case, ARIPO will only be guided by the provisions of the protocol, Section 7. But where it is considering an application that is being filed from a member state, then in the process of filing, it will determine whether the provisions of Section 7 have been complied, but in particular whether the national requirements have also been complied. So it will not just only be ARIPO provisions, but it will also defer to the national provisions to determine whether the application complies with the provisions of Section 7. Now, when examining applications for registration, in terms of sections 5.4, 6.3, and 6.4, ARIPO shall be using the provisions of, can we go to 5.4, please? We've been to that before. So this is in those, I've actually explained it already. It is in those instances where we said applications will be made directly to ARIPO.
Madam Chair, could I raise an issue? Sorry to interject. Madam Chair. Yes, I just wanted to, the version that I have of the draft protocol is different from the one that is being presented. And we had, at least for myself, I'd come up with some comments on that, so I don't know how to proceed when the one being presented is not what we had initially gone through in preparation for this meeting.
Okay, I don't know how many are in that same problem. So what shall we do? Do we just beam here the one that the version that you are presenting? Maybe that will help.
And some of us would be eliminated again because we have this version.
Yes, I also have the same.
Yeah, we have this version.
Yeah.
In fact, we had both versions. The one that they are referring to was the first one sent, and later this was
They
sent.
sent this one, yes.
Yeah.
Yes?
Yeah, can we, to just speed up things with them, those are closer to us, can we just get their emails? Those who have them, we can just share with them very quickly so we can be on track because of time.
And there's also a message here from WIPO that's saying, from Lanteri Paolo, that the annex with the actual draft protocol is not available on the ARIPO website page. The www.aripo.org/diplomatic conference. The document is not there. So is it possible to have it shared now? Pardon?
Yes, Madam Chair, it's possible that it be shared.
Okay.
Yes, sir. Thank you.
So how do we proceed now? Do we use the, can you just beam the document for our benefit, especially for those that have a different version?
Yes, Madam Chair. Yes, Chair, can I say something?
Yes, please. While they're trying to arrange.
You
Yes,
just
Sierra, yeah.
yeah. You suggested that the final draft should be circulated to the gentleman and others who've not received it. Or should we ask them if they'll be comfortable with that? Because the gentleman who interjected said he had already made a note on the first draft that was sent. And I suspect the final draft maybe would not contain the issues he had noted, he had taken note of. So will they be in agreement if we circulate this final draft to them? Would that be okay for them? Thank you.
Yeah, yes, Uganda, please.
Thank you, Madam Chair. I would imagine that the new draft has addressed some of the comments that I raised from the first one, but because I haven't looked at it, and quite a number of people who haven't yet seen it, then we wouldn't know. Probably it would just help if the current presenter just gives a summary as he has been doing, then we'd have to go detail by detail as he suggested, and then that's when we'll be able to address any other comments.
Actually, after the consultant makes his presentation, we'll go section by section with this one, starting from the preamble and thereafter. So then people can be making comments as per sections of the draft protocol. So what he was doing was just to give us an overview, actually, of what is in the protocol, the draft itself. And then thereafter, we move on to look at specific sections. Yeah, so I don't know if that will help you, because of course you may be able to make your comments as we do we look at the specific sections. Yes.
Thank you very much.
So while Maureen is trying to arrange something, is it okay if we proceed in the way that the presentation was being made, so that our consultant finishes taking us through some of the general comments that have been made, and then thereafter we move on to the specific sections of the draft protocol? Is it okay if we move on in that direction? Okay. Thank you. It seems it's agreeable. So, Dominic, please, you may continue with your presentation.
Thank you very much, Madam Chair. There's also what we thought was also important to highlight, the transmission of the application to ARIPO, whether from national states or from non-member states or citizens of non-member states. So this is in terms of section 6.1. Where contracting state has appointed a national competent authority within its territory, the copyright in such instances, the works, will be submitted by the competent authority that has been appointed by the state. But where there has been no competent authority appointed. And in instances where ARIPO has now designated, no, national states designate ARIPO as the competent authority, the members of that state, through their representatives or in person, will be able to transmit their applications directly to ARIPO. They won't need intervention of the state organ. It will be direct. So in that case, again, ARIPO will be receiving and registering the application and also providing the notification. The same will apply in applications from non-contracting states or citizens of non-contracting states. In those instances also, the right holders or the representatives will be able to apply directly to ARIPO. So it means that ARIPO will continue to have a dual function depending on whether there is, in the member state concerned, a designated authority, and depending also on whether ARIPO has been designated the competent authority by the national state, or also depending whether the application is being made by a citizen from a non-member, or it is coming from a citizen of a state which is not a member to ARIPO. So in those cases, ARIPO will continue to do the dual function. Now, we have talked about cancellation and challenges to the registration. So these are procedures that the protocol has put in place to provide for the invalidation of a registered copyright work. What will happen here is there are two instances. This can be done both at the national level, where the registration was done, and also at ARIPO. Now, the reasons for, and this is provided for in section 13.2 of the protocol. Now, the reasons for cancellation or invalidation are provided in section, is it 3.1? 13.1. Yes. And these include error and fraud. So there's still room for aggrieved persons to challenge, to invalidate a registration that has already been entered in the database, or even at national level. So where the challenge was made, the invalidation was initiated at a national level, then ARIPO should be notified of that invalidation in terms of section 13.4. Now, to provide for the challenges and dispute mechanism, section 18.2 provides that ARIPO shall, in consultation with member states, provide for dispute resolution concerning the application of the protocol, including also the disputes on the interpretation of the protocol. These are the highlights that we thought we should bring to the attention of the experts to appreciate in detail what this protocol is about, how it intends to facilitate for registration. And then when we go through the provisions, we've highlighted the substantive provisions. When we go through these provisions, then we're going to have in mind the highlights that we've given and the context in which they interact amongst each other. I don't know if there are any questions on the brief introduction that I've made. Madam Chair, I was just done with my highlights.
Yes, oh, thank you very much. Sorry. So I'm told this version that we are using now is available on the app, the ARIPO app, and the website, the ARIPO website, or the Diplomatic Conference website. So now I understand the confusion. The document that our colleague from Uganda referred to was the very first one, and the comments were made and taken into consideration, and this is the revised version that we are working on with all the comments that were submitted. So this is the version that we'll be working on until tomorrow, okay? The one that is available on the website.
Madam Chair.
Yes, please.
Good afternoon, participants. Through you, Madam Chair, I would want to ask Mr. Runiga to make a statement and clarify exactly what you are saying and give the right picture. Mr. Runiga, please.
Thank you, Madam Chair. Distinguished delegates, we are sorry for any confusion that was caused by this, but I just want to confirm what Madam Chair has just said. Professor Kakosa, in 2020, when we circulated the first draft seeking, it was at the consultation phase, when we were seeking inputs from member states and all other cooperating partners and other stakeholders. That was in 2020 April. Then when we got all the comments and other inputs, we put everything together, and that final draft is what we circulated with the first invitation in April 2021 to this diplomatic conference, when the meeting was initially scheduled for July. So that's the draft we circulated to all member states. We really, we are sorry if it was not maybe received by some of the participants in this room. That was what we circulated. And again, in July, we circulated to all member states all the working documents. We sent zip folders to all member states for the expert meeting, the administrative council, and also the diplomatic conference. So, and this is the version that we sent. Yeah, it's understandable that there can be a confusion of version, but we apologize for that. And what we are now putting on the website and going to project now is that final version that was circulated. So, Madam Chair, I submit to you. I hope it is clear.
Thank you very much, Pierre. I'm sure it's very clear, isn't it? So that we proceed. And if we want to access it, again, it's available on the website, the ARIPO website. You do /diplomatic conference. And the password, as you already know, is ARIPO DC 2021. ARIPO with small characters. The first letter only is capital A. The rest, RIPO is small characters, and then DC capitals, and 2021, what is this? Exclamation mark at the end. Okay, so thank you very much for the presentations, both from the Secretariat and from our consultant. We'll now go into looking at the protocol section by section, starting with the preamble. And the way to do it, we'll be asking you, our experts, to comment on every section if you have comments, that is, or questions that need further clarification. And then after we're done with the preamble, then we go to a particular section, for example, section 1 on interpretation, and if there is anything that you need to comment on in that particular section, you raise that. And that's how we are going to move on. We'll not be going by announcing a section and a subsection. But as I said, what is going to happen is, for example, I will mention we go to section 3. And if somebody has issues there, then they will raise mentioning a particular subsection if that is the case. Is that okay with all of us?
Chair.
Okay? Yes? Yeah?
May I propose through you that we perhaps start with the substantive provisions of the draft protocol, because as you may be aware, the substantive provisions would then guide the formulations that would appear in the preamble. So I would propose that the preamble be skipped and we move on to the substantive provisions, and then we revert to the preamble later on. I submit, Chair. Thank you.
Thank you. Malawi proposes that we start with the substantive provisions. Do we all agree with that proposition? Or how many agree and who disagrees? Who opposes? Sierra Leone, are you raising your hand? No? Okay. Sudan? Okay. Anyone? Okay then. So we start with section 1 on interpretation. If you agree, so can we have the draft beamed up there? So we have section 1 on interpretation. So we have administrative council, what it means, ARIPO database, contracting state, copyright or copyright-related right subsistence, copyright holders, the definitions, copyright registration certificate and copyright work, jury authorized representatives, his national competent authority, notification certificate, person, regulations, voluntary registration, and so on. I think that's the end. So those are a list of the definitions. Who wants to start with commenting on those? Even our online colleagues can also make their submissions now if there are issues on the general interpretation. Perhaps we could look at administrative council in the interest of time. Yes, please.
Thank you, Chair.
Malawi.
I don't want to propose a definition for administrative council, but my comment is with regard to the chapeau itself under the opening statement under the section 1. I would propose that it reads for the purpose of this protocol and ends there, and then starts with administrative council, because the rest of the wording there kinds of well, you cannot say that it having the meaning assigned to them and then say administrative council means kind of a construction issue in terms of the sentence. So I'll propose either, I don't know what value the rest of the words after protocol adds, so I'll propose the removal of the rest of the wording from protocol, and then it jumps onto the definition after protocol there.
Thank you. The proposal from Malawi is we delete the part that starts from the following definitions: shall, unless the context otherwise requires, have the meaning assigned to them. So that the first, the chapeau itself just reads, for the purposes of this protocol, then we go straight into the definitions. Any objections? Or do we agree that we delete the rest of the, yes, Sierra Leone?
Chair, can you come again, please?
Okay, the proposal is that the part that starts with the following definitions shall, unless the context otherwise requires, have the meaning assigned to them. so that we only start with, for the purposes of this protocol, and then we go into the definitions.
Chair?
Yes, Chair. My take on this is as follows. You say the meanings given to these words are as follows. What I would suggest, unlike what my colleague delegate has proposed, is that we remove the expression unless the context otherwise requires, because we will not be referring to any other context. The context we are referring to is what is contained in the protocol. So I'll suggest we have something like, for the purpose of this protocol, the following definitions shall have the following meaning assigned to them. Thank you.
I didn't get you properly. But if we could have the document reflected here, maybe it will be helpful for some of us.
I was saying, what we have now is, for the purpose of this protocol, the following definitions shall, unless the context otherwise requires, have the meaning assigned to them. What I'm not comfortable with is the expression unless the context otherwise requires, because we are limiting ourselves to what is contained in this protocol. So we are not, or we will not be referring to any other context or any other interpretation of any word or expression, but we'll just limit ourselves to the interpretation given in this interpretation section. You see, so therefore I am suggesting that we remove the expression unless the context otherwise requires. Because this gives the impression that, I mean, one can give a meaning to the words listed in this interpretation section. But if we are to restrict ourselves to the meanings in the interpretation section, then I would suggest that we have something like this. For the purpose of this protocol, the following definitions shall have the meaning assigned to them, or shall have the following meanings assigned to them, wherein we only limit ourselves to the meanings, the definitions we have given to the expressions that we use in the protocol. I don't know if I've made myself clearer now.
Yes, you have. But yes, let's hear from Kenya and then the Gambia first. Yes. Thank you.
Thank you, Chair. I want to agree with both the gentlemen that have preceded me. My thinking is that when we say the following definitions shall, unless the context otherwise requires, means that we are opening up ourselves to several interpretations. And so we want to give it a meaning, but at the same time say, but then you can interpret it the way you want, depending on the situation. So I'm thinking we just agree and decide to give it the meaning we want, and then have that be the interpretation, because that may be a subject of a lot of interpretations going on around it. So to me, I would remove that unless the context otherwise requires, because then we are giving it meaning and giving it the context that we want. And then when we say, I think the other part of having the meaning assigned to them is with English, it's just a repetition. Because we are saying having the meaning assigned to them, then you go again and say, this means this means this means this. So if we remove that having the meaning assigned to them, we still have administrative council means 1, 2, 3. So for me, I would agree with the gentleman who went first. I'm sorry if I didn't get your name or who you are, but you're recognized, highly recognized. For the purposes of this protocol, then we move on to the meaning. Administrative council means this, ARIPO means this, contracting states means this.
Okay.
Thank you, Chair.
Thank you very much. And the Gambia, yes.
Yeah, thank you, Madam Chair. All protocols respectfully observed. I would like to just join my colleagues in giving my perspective in the interpretations in here. I would like to support the first speaker in terms of referring, clearing all the statement. The following definition shall, unless otherwise requires, because I think there is a lot of generic words in here which do not necessarily go out of context, because looking in all the generic words in here, you would tend to understand they are referring to exactly, even in the traditional or in the common English language or dictionaries, they mean the same thing. There is no kind of banal word or different word that is being used in here, which means it's specifically meant in our local terms. So most of the words that are being used here or interpreted, they meant in normal English, they meant the same thing. So there would be no point in giving a choice in terms of the other word, if it means in the local language or in the dictionary word, this thing, or in the general meaning this, then here we mean this in this particular situation. So I don't think there is any need to make a difference in it. I would like to support the first speakers.
Okay, thank you. Thank you very much. And we have comments by our online participants. One from Eswatini. He says, we still need the phrase art unless context otherwise requires. Then the other one from Dorothy of Ghana, who says, I think the only words have the meaning assigned to them should be removed. Okay. That's a comment. And then we have Monyatsi from Botswana raising her hand. I can't see that. Raising her hand. Miss Monyatsi from Botswana, if you are able to hear us, could you please take the floor? Virtually.
Can you hear me?
Yes.
Good afternoon, and thank you, Madam Chair. I also wanted to concur that we still need the statement that refers to unless, okay, sorry. I just got my documents mixed up. The statement that says unless the context otherwise requires, because that basically says the interpretation as it is provided here is what the words mean. However, it is possible that in the document there could be an instant where a particular word now gives a different meaning. Therefore, that statement is still valid. I would agree with you, Madam Chair, that we probably need to delete the last part that says have the meaning assigned to them. Thank you.
Thank you very much. Namibia, is it Namibia before the Uganda? Is that Uganda?
This is Uganda.
Yes. So,
thank you.
Is it Namibia or Uganda?
Namibia first.
But as a host, you need to give the visitors
okay,
first
sorry,
a
I hadn't
chance.
seen you.
Thank you very much.
Thank you, Monyatsi. But now we move on to Namibia.
Thank you, Madam
Uganda.
Chair. I
Yes.
think Monyatsi has taken my words, that is really standard drafting style. You have to make, because you will not be able to define everything. So you have to make provision for where either you may want to use that specific word in that specific clause differently, or you just did not define it. So we need to just keep it because it's just normal drafting standard, Madam Chair.
Okay, thank you, Namibia, and then Uganda. So we make a decision on this one, if there are no other comments.
Yes, thank you, Madam Chair. I would also like to agree that is standard drafting style. The only thing we have to remove is have the meaning assigned to them, because that's repetitive. But for the words, unless the context otherwise requires, the speaker, the online speaker kind of gave a very elaborate explanation with that regard. Thank you.
Okay, thank you very much. So here we are. Okay, is it Sudan?
Yes, Sudan.
Yes.
Thanks for having me. I agree with the last delegate who says that the last part you don't need to add it, which it's going to be a kind of repetition. the last part of the paragraph.
Okay.
If they can write it again. Oh, yes. Meaning assigned to them. It doesn't, it's kind of repetition. We don't need it. I need it.
Thank you very much. And could we then recast this part where it reads, for the purposes of this protocol, unless the context otherwise requires, is it? The following, or the definitions, there was something that was proposed properly. Shall apply or something like that for purposes of this protocol, unless the context otherwise requires, the following definitions shall apply or something like that. We need to recast that. Yes, Dominic?
Thank you, Madam Chair. Thank you, Madam Chair. Can you hear me?
Yes, we can hear you.
Yes. What if I propose then we recast it as such that unless the context indicates the contrary, right?
Who is making the changes? Because we can't see the changes being made. Somebody should be typing. Yeah, but we need to make the changes. We're maintaining unless the context otherwise requires. Yes.
Chair, perhaps before a proposal on the couching of the new, I just wanted to make a comment to perhaps say, okay, of the definitions that are here under this particular section, I mean, what other context of these words would we foresee? Because I mean, we have particular definitions. It's not like we have the world of definitions. We have particular words that are being defined, and there is a context that we are foreseeing in this particular document. So I think that particular, as was envisaged by some colleagues here, that particular wording opens up this protocol to a myriad of meanings and defeats the whole purpose of having this definition section or interpretation section. So unless we have we have words under this particular provision that we would foresee having other definitions other than what we have provided in this article or section, then I don't see why we should have this unless the context otherwise requires. I'll still so submit, but I'll be subject to perhaps guidance on the reservations that I'm raising. Thank you.
Okay. Thank you very much. Yes, Sierra Leone.
Yeah, and Chair, I tend to agree with the speaker. You see, when it comes to interpreting or giving a definition to the words in the interpretation section, I do not think any other definition apart from what is contained here will be appreciated in a court of law. The court will go strictly by the definition given here. If a word has not been defined, then the court will look at other definitions that suit that particular word. But as long as the word has been defined here in this section, the court will never deviate from the definition given in this section. You see, so I still, go by my first proposal regarding the use of the expression as the context shall otherwise requires. Because if we are to maintain that, then that gives the indication that we can give a meaning which might be different from the meaning given in this interpretation section. And the point put across by previous speakers that maybe a word might not have been defined, so you can give it a definition. That is correct. You can give that word which has not been defined here